that we have. The Corporate Transparency Act seems really scary, but it's really not. Um, it's pretty basic requirements, and it looks scary, but it's not once we break it down for you and tell you what you're responsible for. So, all right, here we go. Well, it is 12 o'clock on the dot, so I want to start. I'm getting a little bit hangry, and I'd love to eat lunch after this. Um, my name is Christina Morgan. I'm a shareholder here at VF Law. I'm here with my partner, Quentin Cups. Say hello, Quentin. Or don't. You're on mute.
Yeah, I just couldn't find the mute button.
So Quentin, those of you may or may not know, he is the co-chair of the Legislative Action Committee for CAI. Um, so I think he's definitely more knowledgeable on changes in the law, which he's going to do a seminar coming up, I believe, next month on those changes. So if you'll please not ask any questions and save those for the next seminar. I certainly don't have all your answers about the changes in the law. Quentin would have that, but I wanted to make sure that we told everybody about the upcoming seminar. There's obviously a lot of our competitors and CI will offer the legislative update too. I always think it's an interesting spin to hear uh, everyone in the industry talk about the laws because we just don't know how everything's going to be applied. All right, we have a bunch of people who are. This is a very popular topic, huh? I guess because it just became effective in January 1st of 2024, CTA. All right. I don't know that I can even see the chat. So Terry, you're gonna have to help monitor that. For those of you who haven't met Terry, she's our director of client relations. So she'll be the one that you follow up for your anybody who needs credits, that kind of course materials, etc. All right. Let's talk about CTA during lunchtime. They're so excited. If I could let me figure out how to, there you go, get my slides. I'm sharing my screen, yet it is not forward. There we go. All right, here we go. We're in business. So what is the Corporate Transparency Act? What is this? It's often referred to as the Anti-Money Laundering Act. There is a counterpart in Canada that was similar. And so why do we need to know about the Corporate Transparency Act? So the CTA, let's talk about its purpose. It was established to prevent money laundering, tax fraud, financing for terrorism. The government believes that if it has more information, that it'll be able to combat these things that will or hurt us, particularly financing for terrorism. I don't know that it was the intention for community associations. I think it was just an accident that we were swept up into this law and its application. Um, there has been talk of wanting to lobby for some exceptions to the CTA, including homeowners associations. That has not happened. And so, as a nonprofit corporation that is established under the Arizona Corporation Commission, HOAs, condominium associations are going to be subject to the Corporate Transparency Act. And it means that if anybody has a beneficial ownership interest, then we will have to report certain information to the U.S. Department of Treasury's Financial Crimes Enforcement Network. So if you hear me refer to FinCEN, Financial Crimes Enforcement Network, I am talking about the feds and the U.S. Department of Treasury. So I was talking about who has to comply. U.S. corporations, LLC, entities such as partnerships. My firm has to comply. I have an S corp that has to comply. non-US corporations and other similar entities that are registered in the United States. And most community associations have to comply with these requirements. There are some exceptions. I think if you have employees and you do more than $5 million worth of business. Is there an HOA? Anyone want to raise their hand of a manager that of an association that does more than $5 million worth of business? Let me see. Okay, here are the exceptions that I was talking about. Gross receipts in excess of 5 million, and then you have more than 20 full-time employees. So that's the exception. Really large community associations exempt for compliance. I don't really think that's probably anybody on this call. And so here's FinCEN. That's what I was talking about before. Just a fancy way of financial crimes enforcement for the U.S. Department of Treasury. Okay. Who's a beneficial owner? So this is the beneficial owner is any individual who directly or indirectly through any contract, arrangement, understanding, relationship, or otherwise exercises substantial control over the entity. Or owns or controls not than less than 25% of ownership interest of the entity. 25% ownership, it is what it is. In practice for HOAs, it's going to be triggered for communities under development with a declarant, or commercial condominiums or smaller associations with a 25% ownership interest. More likely than not, we're really talking about individuals who exercise substantial control. And this is the standard where your directors and officers are required to register with FinCEN as a beneficial owner. So this is that definition of a beneficial owner and who it applies to. I've heard a lot of moaning and groaning, and I totally think that these feelings are valid of this extra reporting requirement is going to chill participation in community associations. I think that's valid. I don't know that people really want to go through this or have this obligation to report. But I will say that if you pay taxes, the feds already likely have this information. So substantial control, senior officer of the company, president, treasurer, secretary, have authority over the appointment or removal of any senior officer or a major or dominant minority of the directors or managers of the company, and then having any direction, determination, or decision power over or substantial influence over important matters affecting the company. So this is your substantial control, includes the following. Again, directors, officers of community associations are going to be those individuals who exercise substantial control. It's our opinion that community managers as agents don't qualify under exercise or don't qualify as far as reporting under CTA. Okay. Here's some more about direction, determination, or decision power. Reorganization, dissolution, merger of the entity. I don't think that really applies. Major expenditure of investments. Obviously, directors, officers are determining where to put money. They often come to me and ask if they could put it in some money market fund or how they should be, how they should be investing some of their reserve funds. That certainly qualifies here as exercising substantial control. A lot of these won't apply, obviously, to community associations. Amendments of any substantial governance documents of the entity, including articles. A lot of these articles, bylaws of incorporation, have approvals that are required by the homeowners. Some of them don't. Bylaws sometimes can be amended depending on the provision by the board themselves, by a majority of the board. You often see bylaws of that nature. So I think there's a lot to say that community associations are going to fall under, and their directors and officers will fall under this exercise of substantial control. This is like watching paint dry, huh? This is amazing. Well, the good news is that this seems complicated, but after an hour, if you've had any training in this before, then you'll understand that compliance isn't super hard. If you have the right tools, and I'll explain that to the end of how our firm is dealing with it and how we've already reported for our individual S corps and how it can be easy for you too. Okay, so you're not a beneficial owner. Of course, there are always exceptions to the rules. Minor kids, but you wouldn't have any minor children serving on your board of directors. At least I hope not. We might act like children, but we're not supposed to be children. Uh, Employees of a reporting company acting solely as an employee who has substantial control over economic benefits from the entity is derived solely from the employment status of the employee, provided such person is not a senior officer. So employees of the company, like I said, even if an association probably was self-managed, I think there'd be some exceptions for a beneficial owner, whether they qualified as a beneficial owner. And then obviously creditors. I don't know when individuals whose only interest in a reporting company is a future interest through right of inheritance. I don't know when that would apply to us, but that is an exception. Okay, here's the meat and potatoes. What do we have to disclose to the feds, the U.S. Department of Treasury, FinCEN? Your full legal name, your date of birth, your current address, either a unique identifying number from an acceptable form of identification. That's a fancy way of saying you got to give a copy of your driver's license, unexpired passport. I understand management companies, in particular, the hesitancy to collect this information from your directors and handle sensitive information that could be stolen in a data breach, et cetera, et cetera. I think that's a valid, it's definitely a valid concern. And I'll address that at the end too of your options. So, what are the deadlines? The deadlines are December 31st of 2024. So we're here in the middle of May. My goodness, this year has gone by so fast. You have till December 31st to comply your initial registration. After that, you have 30 days when things change to report. If you're having your annual meeting towards the end of the year, I wouldn't report until that time. Save you some hassle. So this is where I talked about protecting personal identification information that we have to give over. I think this is probably the biggest concern, obviously, that's going to chill participation of volunteers, that they're worried about the protection of their copies of their passport, their driver's license, their birth date, other things that could be used to steal their identities, tap into their bank accounts. And so we have a platform at VF. I'll talk about that later. But expect that we will update everyone, and I'll show you later into this presentation how we're managing it. Now, the disclosure obligation is ongoing. So after we hit this deadline by the end of the year, like I said, any 30 days of a change, you're going to have to report to FinCEN. And if anything's inaccurate, you have 30 days to fix the inaccuracy. I think that begs the question, what happens if we don't comply? The cynic in me says, since millions of businesses are affected by this law, how are the feds going to sift through this information, and how are they going to penalize people for non-compliance? I think that remains to be seen. But I certainly think you should try to comply, because the possibility of penalties are steep. So here's where I talk about, if you have an annual meeting, you have 30 days to file an update. That's why I'm saying to those of you that have annual meetings towards the end of the year, I would wait to comply with CTA. And understand, management companies, you're going to have to keep very accurate records, and to avoid the risk of penalties. Well, what are these penalties? I know everyone's dying to know. We'll talk about that. That wasn't my next slide. I thought it was my next slide. So there's been this big debate. When do you let your volunteer board members know that they have this obligation to comply with the CTA. Some have told me, well, we just nonchalantly mentioned that, hey, we have this reporting requirement, or some say they wait until after they're elected. I don't know that there's a wrong or right answer, maybe best answer. I see a couple people smiling on this. I want to stop the share really quick. Would anyone like to volunteer to say how you have been dealing with the disclosure to your potential board members that they have to comply with CTA? Where's the chat? I can't even find the chat. There's a chat. All right. Terry put the legislative update. Any volunteers? Terry, do they have the ability to unmute?
Yeah, they can. They just have to click unmute.
Okay, who's a brave soul to unmute here and tell us how and when you've been telling your board members that they've got to comply with CTA? Anyone? Dave.
Yeah, I just got back from CAI National in Las Vegas, and we all talked about this. And the best recommendation is we need to disclose that up front because you may lose a candidate. And if you disclose it up front, it may be difficult to get candidates. So I have been talking to my boards for the last several months, just mentioning it, telling them we don't know much right now, but it's coming. So now that we're knowing a little bit more, and the advice was register, definitely register. Um, so, and the idea was to have the board members themselves get their FinCEN ID so that we don't have to take their personal information. Let them put that on FinCEN, just give us the code number, and all we have to do is put the code in the registration for the association. So it takes away the need for us to store or even have that information. So I thought that was a great recommendation.
Yeah, you can do that, get your own FinCEN, as Dave said, or you can have a third party administrator or somebody who has an ethical obligation, i.e. attorneys, to store that information. And so I love that you're bringing this back from CAI. Did they talk, Dave, about the penalties at the national conference?
Oh, yes.
What did you glean from that?
You don't want to not do it. They're steep.
They're really steep.
They're steep. And they're daily penalties. I think it's 500 a day
Oops. There
per person.
Yep, there it is. So $500 per day, and then willful violations, fine up to 250,000 and up to 2 years in jail. You know, when you're telling people to comply with the CTA, I wouldn't lead with this as far as the penalties are concerned, but it's actually pretty easy to comply. Because oops, I just left. Let me see. I don't think I'm sharing my screen here. Let me go back here. But it is fairly easy to comply, but I wouldn't lead with obviously what the penalties are. That's what I said earlier in the presentation of I would rather you try to comply and at least there's nothing malicious there, and hopefully there would be some sort of mercy because it's not willful by failing to comply. So let me share my screen again. If I can find my PowerPoint. There we go. Any other words of wisdom, Dave?
I could be funny and say for free drinks over at the bar in the corner, but no.
I like that idea. All right,
there's a lot of good sessions.
Sure. I'll be interested to see how the feds really manage this information and what will be connected to stopping money laundering or these tax fraud or whatever, and if that's going to be linked to some enterprise with HOAs. We've certainly seen our share of embezzlement and other financial crimes go up since the pandemic. with HOAs, but I don't know that I've seen something connected to some organized crime and money laundering on that issue. We certainly have seen the managers that run off to Las Vegas, and then have personal problems or addiction, substance abuse, those sort of things. So I don't know how this is going to be effective. What is really interesting to me is that the CTA was a bipartisan effort. Both the Dems and the Republicans voted for this law. And I don't know anything about its effectiveness in other countries such as Canada, et cetera. But you're talking about millions of businesses that are affected by this. So it's going to be an incredible amount of data that's going into the U.S. Department of Treasury.
And they also said the reality check is there's no enforcement people to follow up on the enforcement. And that's a known fact, but not worth the risk.
Sure, right. I totally agree with that. Maybe one day it will be funded where we see it. It just sounds like more paperwork, but here we are. There was an Alabama case, and I don't know if they went over that, Dave, where there was an injunction with compliance. The problem is the feds and in that the business in that case agreed that the injunction only applied to them. So it doesn't apply to any of us poor souls. So everyone thought, hooray, we don't have to comply. And then just kidding. Yes, you do. So, and the nitty gritty of that case, we don't want to get into, but pretty much we're not sure it's going to be struck. CTA is going to be struck down. So, in other words, comply. All right. There is a guideline publications at FinCEN. Here's the beautiful website if you are just dying to do your own research and there's certainly things on the CAI website for you to take a look at that they've published about CTA. I would say that is important. Obviously make your directors your directors aware that this is the type of information that they're going to need to report to the Treasury. And then so let's see. I don't know what company applicants. Oh, we don't think that it complies. All right, this is where I talked about the penalties. They are rough. Dave just said $500 per day and felony subject up to $250,000 and 2 years in jail. The penalties are just too steep to not comply. Let me show you a couple of things. So, Terry, you can stop recording at this point. We have, and when I mean we,